and CJI Chandrachud has said that the judgment is in 4:3 ratio. So it is a historic judgment that's in fact coming in, overruling the 1967 judgment in S. Azeez Basha versus Union of India, which held that an institution incorporated by a statute cannot claim to be a minority institution. Issue whether Aligarh Muslim University is a minority institution is now left to be decided by a regular bench based on this view of the majority. In Azeez Basha, the court had ruled that the AMU cannot claim minority status as it was established by a statute. Today, the majority led by Chief Justice of India DY Chandrachud overruled Azeez Basha and held that an institution will not be losing its minority status merely because it was created by a statute. Joining me on the broadcast, in fact continuing to be with us, is Senior Advocate Rajiv Nanda. Advocate Nanda, at this very point, let me also draw a comparison with what had been said in the Allahabad High Court, the judgment that had come out in 2005 and that had denied the minority status, and the 4 judges who in fact were for the minority status today in the Supreme Court. If you could just draw a parallel and a comparison between these 2 judgments that have been passed.
See, Allahabad High Court denied them the minority status. They said that since this was established by essential regulation, so establishing and incorporating will not make a difference because you are established under a central act. So therefore, you cannot have reservation of more than 50% for Muslims in, let us say, the medical college seats and all those. This was the view of the Allahabad High Court. By later amendment, this was tried to be diluted. But now today, the 4-judge bench has held it is no matter what it is a minority institution which was established by minority, though it can have outsiders who are not from the minority. But all this is a theory which they've laid down. Practically, the roadmap of how this will function will be decided by a regular 3-judge bench. Please take note of the fact that 7 judges bench or 5 judges bench are not the regular benches of Supreme Court. They only are constituted upon reference by smaller benches when there is a conflict between 2 or 3 judges. So they refer it to a larger bench. In the 5-judge bench, they thought that perhaps it will be appropriate, so Justice Ranjan Gogoi had referred it to a 7-judge bench. Now, at that point of time, the Honorable Chief Justice Gogoi. Now, this decision has come, but what is there on ground? It is 4/3. So, as I had earlier also stated, I'll reiterate that this would require a still reconsideration by a yet larger bench. And practically, this cannot be considered as the 4 judges cannot overrule 5 judges. The earlier decision was, Basha was 5 judges. And that was by an absolute majority, the total 100% majority. There was no dissent. So 5 judges cannot overrule, 4 judges cannot overrule 5 judges. But the strength of the bench is 7. So this will be considered as a 7-judge bench decision. So as I had earlier said, this would, in my view, require a reconsideration or yet elaborate consideration by a still larger bench.
Right. In fact, as you speak of a reconsideration, when we speak of the regular bench having to step in for this particular judgment, help us understand this, that what might, based on the verdict that's come out so far, what might end up being the focal point of a bone of contention within the regular bench as well, if at all, over this entire matter?
Well, I don't think there will be any much contentions except for some fireworks here or there about the running, because largely the 7-judge bench has laid down the principles on which it has to be run. The smaller bench will perhaps have to draw some commas and full stops here and there as to how the things are to be done. They will not be in a position to go against what has been laid down today. So something, if has to be done against this judgment, will have to be done by a larger bench. not
So,
by a three-judge bench.
right.
They will not be in a...
Right, continue, continue, advocate.
Yes, they will be the three-judge bench, which will be a regular bench, will only be, if I can say, lay down certain norms based on the principles today held. They will do some do's and don'ts, which should have been left to the governing body of the AMU itself. Once having held that they are minority, they can establish all those rights should have been left to the AMU governing body, not for the three-judge bench. I don't think so. Though I'm yet to read the entire judgment, I'm not in a position to criticize it, and I'm not. This is my prima facie view, what I'm hearing and what I'm reading from the news, because I am yet to see it is in the process of being delivered. So as and when we'll have the entire judgment, we'll be in a much better position to comment on it. But whatever is coming in news and whatever I'm hearing is this, that they are leaving for the nitty-gritties to be drawn by the smaller bench, which is perhaps a impractical decision.
Right. At this point, since you say that you haven't, gone through the verdict in details, let me bring to you one particular statement that's in fact been made by Justice Sanjeev Khanna. He has said that, in my opinion, reference was not in terms with established norms of judicial propriety. That is one of the major reasons he has dissented to this very minority status for AMU. What do you think? Could you just translate this for the viewers out there? The main point of dissent for these three judges who have gone against the ruling which favors the minority status to AMU.
I'll see.
From whatever you've gathered so far, what seems to be the top point that's been made by these three judges?
Yeah, as far as the observation as reported, that of Justice Khanna, Honorable Chief Justice Designate Sanjeev Khanna, that the reference was not as per the judicial way it ought to have been. See, as I was earlier also telling you, these three judges bench or two judges benches are the normal benches of the Supreme Court. Once they feel that there is a decision by yet another bench of the similar strength, and this bench whose hearing is not holding the same view, so they refer it to a larger bench. They frame a reference question, which is to be answered by the larger bench, which could be 5 judges bench. The situation can be, they feel that this question is of such importance that it will have greater ramifications on the country. So they refer the matter to larger bench, the second situation. Now, here the bench of Justice Gogoi has not followed, this is what I feel Justice Khanna has meant today, has not followed the mannerism in which, the judicial mannerism in which the reference ought to have been made about the minority status of AMU. So he has held that the judgment of Basha is holding still good, and it doesn't hold the minority status. AMU doesn't hold the minority status, because had there been a proper reference in a proper manner, then the bench was bound to answer whether AMU is a minority institution or not. These are all technical things. It is difficult for a layman to understand, but I have tried my best to explain it in as simple manner as I can. What is the larger bench, what is the smaller bench, and how the reference is to be made. These are quite technical things to be understood.
Supreme Court by a 4-3 majority has overruled the 1967 judgment in Azeez Basha versus Union of India, which held that an institution incorporated by a statute cannot claim to be a minority institution. The issue whether Aligarh Muslim University is a minority institution is now left to be decided by a regular bench based on this view of the majority. In Azeez Basha, the court had ruled that AMU cannot claim minority status as it was established by a statute. Today, the majority led by Chief Justice of India, DY Chandrachud, overruled Azeez Basha and held that an institution will not lose its minority status merely because it was created by a statute. With that, joining me back on the broadcast is Varghese Abraham from our newsroom. Varghese, coming back to you, there are some very crucial points that's been made by senior advocate Rajiv Nanda, who was with us in the broadcast, one of which is that while a regular bench is to be reviewing this particular verdict, he's also said that this is up, he's very sure that this will go up in front of a 9 judge bench, because the 4 people who've given in favor of the AMU being a minority university comes against a 5 judge bench, which all of who had agreed that it is not, minority status is not to be given to AMU. So it's still falling short of 1. So which is why he said that it is to go up to a 9 judge bench. Do you think this is a possibility at this given point, given the verdict that's come out?
Well, see, if you look at the manner in which the verdict has come in, we are looking at a 4-3 this thing, where you have 4 judges, in fact, giving the majority judgment, and 3 having a different opinion on the end. I think 4 opinions is what the CJI said, a majority opinion being 1 and 3 being the other. Now, the question that is being raised over here is whether it will go to a 9 judge bench for reference is again a critical question that can be answered only after a special part of that order should be in fact read into, where it says that this minority status will be later decided. Right now, the SC has said that the AMU is only entitled for the minority status as prescribed under Article 30, which has got which is not absolute, and therefore the minority status of the institution will be later decided by a 3-judge bench. So the SC has given this aspect of deciding whether AMU is a minority institution or not to another 3-judge bench. So right now what it has said is that it is entitled to. So it has made a distinction in between deciding whether AMU is a minority institution or not to the fact that what are the statutes that are provided within the constitution. So that is what it has said. The CJI has also interpreted that Article 30 is not absolute and also has given an interesting factor saying that the question is about looking at who has established this institution, and at the same time not by the to understand its minority status and not by the statute of the law by which it has come into existence. So that is an aspect of it which has been brought into focus over here. Secondly, that has been needs to be looked into critically is that the court has also said that as long it is not necessary that the minority members need to run or regulate the institution. The minority aspect is such that the minority character shouldn't be infringed while the regulation is taking place. So under Article 19(6), we have the administration can be run by the non-minority persons who's in fact looked into. So this is how the court has seen. So whether it will go further is yet to be decided on whether the minority status will be decided by the 3-judge judge panel that has been established in this particular verdict by the court, Shreya.
Right, Varghese. In fact, joining me in the studio is Brijesh Pandey, my colleague. Brijesh, I would in fact come to you with the same question. Will it go to a 9-judge bench at this point?
No, it will not go to a 9-judge bench, and Varghese very clearly pointed out, and the fact is that what the Supreme Court has done today. See, there are 2 judgments which have come out as far as the minority status of Aligarh Muslim University is concerned. The first one was 1967 judgment where a 5 judges bench held that the Aligarh Muslim University does not has a minority status. It's not a minority university, and it removed that minority tag. In 2005, there was an amendment which was done by Aligarh Muslim University in 1981 where they, changed that administration. It was founded by a Muslim and administered by a Muslim, and later on, they in 2004 or 5 they announced a 50% reservation in medical seats to Muslim students. This was challenged in Allahabad High Court, and in 2006, Allahabad High Court junked both the amendment as well as the decision and held that Aligarh Muslim University does not enjoy a minority status apparatus. Against that, the Aligarh Muslim University went to the Supreme Court and later on, since 5 judges bench had already decided that it cannot have a minority tag, it went to 7 judges bench, and 7 judges bench, what it has done is that it has said that by 4-3, it has said that it is entitled to minority tag. It has redefined Article 31, which was the guiding principle till now. It has said that it is not absolute, it is not final, and there are various correspondence which has come into, which has to be examined to figure out, how exactly it was done. What it says is that it paves the way. It paves the way for Aligarh Muslim University to a minority status, but it does not confer the minority status right now. What it has done is that it has changed the reference point. It has said that it will go to a 3 judges bench, will be announced soon, and that 3 judges bench will decide whether the AMU will get a minority tag or not. But what the Supreme Court has also done is that Supreme Court has changed the reference point. Now, earlier, the reference point was 1960 just 5 judges bench reference. Today, the reference point for those 3 judges bench would be today's judgment.
Right.
So the reference point has changed, the understanding of Article 30 has changed, and by 4-3, whatever the Supreme Court has said about, you have to talk, you have to see correspondence, you have to see, various other documents which has been filed, whether this is absolute, whether this is not absolute. All of today's judgment will be used as a referral point by the 3 judges bench, which will then decide whether AMU gets a minority tag or not. But on the face of it, I think it's a big relief for AMU. Otherwise, if you go by 67 and 2006 judgment, looked like the door was closed as far as the Aligarh Muslim University is concerned.
Right, Brijesh. I think that clarifies a lot of doubts at this given point with regards to the verdict, which also brings me to my next question at this point. For the 3 judges who haven't given their, haven't favored in particular minority status for the AMU, what was their major point? What was the major point that they have made for their dissent, that comes up in focus for their dissent?
See, the thing is that what they are saying that what they are saying is that that whatever the reference the Chief Justice of India found, like Justice Suryakant said, that it is crucial to determine whether reference was only to determine an institution is minority or not. In my opinion, reference was not in terms with the established norms of judicial propriety. He also goes on to say that this will place Chief Justice in an untenable position where he'll be bound by technical issue. He said we cannot bring ourselves to terms how a 2 judges bench could dictate the Chief Justice on how a bench has to be composed. Only the CGI can decide. And the 2019 judgment of the 3 judges bench making reference was correct. And what they're saying is that it is not like what the Chief Justice has said. They're completely contrast to what the Chief Justice was saying. So it is the 3 judges bench, 3 judges out of the 7 judges, they have a different aspect or the different thought process as far as this entire judgment is concerned. But I think by 4-3, it is a big victory for Aligarh Muslim University, because now the road has opened, door has opened for them to get the minority status. The 3 judges bench will be conferred. It will be interesting to see who all gets to be part of the 3 judges bench, and how it moves on forward.
Which also brings me to the Article 30 being diluted as a point that's been mentioned by the CJI today, that Article 30 would be diluted if it was just to considered in terms of institutions that have come into being after the Constitution. If you could just throw some more light as to what all it refers to and how this helps this particular case.
Well, the Chief Justice of India went on to say that, he asked this question himself. They say, like, what are the criteria for an institution to be considered minority under Article 30A? I'm just reading from the, what all the Chief Justice said in the verbal and also in the part of the judgment. He said that the Solicitor General has stated that the union is not pressing the preliminary objection that a reference cannot be made to 7 judges. It cannot be disputed that Article 30 guarantees minority to not be discriminated against. The question is, does it have a special right along with right to non-discrimination? He said that an educational institution established by a citizen can be regulated under Article 19(6). The court has maintained that right under Article 30 is not absolute. He goes on to say that the right under Article 30 is not absolute. Regulation of minority educational institution is permitted under 19(6), provided it does not infringe the minority character of the institute. He also goes on to say, and I read, Article 31 cannot extend to a situation where a minority community which establishes an institute but has no intention to administer it. The ones who wants to be greater state control cannot have a minority tag merely because of the establishment, and this can be done by way of waiver. Then he goes on to address, they're saying that, Article 30 shall stand diluted if it applies to only institute those who have been established by after the constitution come into force. Thus, educational institutions established by minority which was established before the constitution come into force will also be governed by Article 30. This was the line which was taken by the 5 judges bench in 1967. But now they are saying that that cannot be applicable for institutions who were formed before the constitution was framed. So I think, you know, he has also clarified about what exactly he feels, and that is the reason why the interesting thing is that now when the 3 judges bench will be formed to decide whether the AMU will have minority tag or not, status or not, the reference point will be the judgment of today which has been upheld by 4-3, which overrules the 1967 5 judges bench of the Supreme Court.
Right, and so when we speak about this 3-judge bench in front of who this case is to be taken now, what would you say is probably a probability for a bone of contention among those 3 from this very verdict? Is there any, do you think, as a reference?
I think, you know, the reference point has changed completely. Now they will not be looking at Article 30 the way 1967 judgment decided. Now they will be looking at Article 30 under
according
the way,
to this judgment.
according to today's judgment.
Absolutely.
You know, 7 judges bench decided by 4-3 in favor of Aligarh Muslim University. And they will also be looking into a host of, decision which has been said by the Chief Justice, where it goes on to say that, you know, reference point has to be the correspondence which has been made, letters which have been written, and the entire gamut of correspondence which is there will have to be looked into, and that is going to be the deciding factor as far as this particular case is concerned.